everybody can hear me okay, and the camera is there. Everyone on Zoom, okay?
Yes.
Thank you. So welcome everybody to this seminar in the Law and Humanities seminar series here at the Peking University School of Transnational Law, Beijing 大学国际法学院. For those of you who are new to our school, we also call ourselves STL for short. STL stands for School of Transnational Law. My name is Norman Ho, and I teach here at the law school. I'd like to welcome everybody here in person who is joining us, and also would like to extend a warm welcome to those of you who are online joining us. We're very privileged and honored today to have as our guest speaker, Professor Nohyoung Park, who is Professor Emeritus at the Korea University Law School. And Professor Park taught for many years at Korea University Law School, in addition serving as Dean and Vice President there. His research areas include international economic law, cybersecurity, data privacy, negotiation, and mediation. He's held various significant appointments, including the president of the International Cyber Law Studies in Korea, former member of the Korea International Trade Commission, and also, among his many other honors, founding president of the Korea Society of International Economic Law. Professor Park will speak to us today on the topic of the development of international rules on cyber, focusing on the United Nations, or this updated title, International Lawmaking for Cyberspace. He will speak for about 45 minutes, and then we will open the floor to questions both in person and on Zoom. I would like to give the floor now to Professor Park.
Good afternoon, and I'd like to thank Professor Ho and Professor Qureshi for inviting me to this great seminar. And it is my first time to be here at School of Transnational STL. And I'm going to give a presentation on I call international lawmaking for cyberspace, and focusing on what has happened in the United Nations. For 40 minutes, I have many things to discuss with you, but given a limited time, I'll be very short for each item. I'll start with the kind of introduction, and then I'll move to what's happening in the UN through the group of government experts, GGEs, and also OEWGs, open-ended working groups. And then I'll move to discuss a bit on international law applying to cyberspace and the norms of responsible state behavior in cyberspace. And then there has been a discussion for whether we need a treaty on cyber. Then I'll touch on it very briefly. And also UN Security Council. And then there is a very brand new treaty which has been finalized very recently, and it is now waiting for the adoption at the United Nations General Assembly, probably in December this year. And then cybersecurity for digital trade and geopolitics and observation. I finished this within 40 minutes. And cyberspace. It should be defined. I mean, we are learning law. When we learn the law, we should have first definition, because in and out of the definition, depending on that definition, the law may apply or may not apply. So cyberspace should be defined, but it is not yet clearly defined internationally. So I think you have some idea on what it means, but the last point, in the UN, cyberspace does not mean but directly, but is understood as the use of information and communications technologies, ICTs. I personally understand it is more used by Russia. Russia has been an active initiator of the rules on cybersecurity in the UN. And cyberspace is an easy playground for individuals, companies, terrorists, and criminals, as well as states. And also, malicious activity in cyberspace knows no international borders. So, for example, the NotPetya ransomware attack in 2017, originally it was done to Ukraine, but spilled over to Germany, Poland, the US, Italy, the UK. So cyberspace is not defined within a particular country. I mean, when cyber attack comes, then any country may be affected. And also cyberspace can be manipulated even by individuals. So it raises a new issue. For example, when we talk about the armed conflicts, the IHL, International Humanitarian Law, applies, then one of the important principles is distinction. I mean, combatants and non-combatants should be separated. But I mean, during this cyber war or cyber warfare, anyone who can use computers and to get in such cyber warfares, then even those young, I mean, school boys and girls might become a combatant. But it is not yet clearly settled, but it could be a very important issue. And there is a very big conceptual difference between cybersecurity and information security. Western countries like the US and the others, they want to use cybersecurity, but China and Russia in particular, wants to use information security. So information security is rather a bigger concept than cybersecurity, because it has the information element. But in the beginning, the Western countries are worried about the information element in the security context. It might negatively affect the freedom of expression and the right to know or right to information. But somehow these days, you have heard about misinformation and disinformation. So the manipulation of information might or really affect negatively even the security of the other countries, or for example, the election might be negatively affected by the manipulation of information. So I think these days, information security might be relevant. But cybersecurity looks at the technical security of the system. Actually, Russia raised an issue of information security or cybersecurity in 1998. At that time, many countries, including the US, did not welcome that idea because Russia might have some different idea. But the US and the others changed their mind when the cyber attack occurred against Estonia in 2007. There was the Warriors Monument in Tallinn, and then Estonia, liberated or separated from Russia. Then Estonia wanted to change the site of the memorial. And then Estonia was attacked through cyberspace. So it was a very shock to the world. So even the US and the others had a different thought about cybersecurity. So, even the US and other countries joined actively the discussion on how cyber is regulated. And if you have any interest in cyber law, in terms of international law, then you should find the book, Thailand Manual. The first edition was published in 2013, and the second edition, 2.0, was published in 2017. Although it was supported or sponsored by the NATO, but it is not a result of the intergovernmental effort to define how international law applies to cyberspace. It is a result of the academic the deliberations on if international law applies to cyberspace, then what could be. So it's kind of textbook. And I recommend you to read, especially the second edition. It covers international law, and then also it covers how international law, the current or existing international law, applies to cyberspace. So I'd like to move to what has happened in the UN. UN has 193 members, or member states, so they cannot, altogether they cannot deal with these issues. So so-called GGEs, group of governmental experts, and later and currently OEWGs established. But as I said in the beginning, Russia initiated the discussion of cybersecurity or information security at the UN in 1998. And also I said the US and its like-minded did not welcome that idea, but after seeing what happened in Estonia, they changed their mind. And I'd like you to understand what's happening, in the UN. As you know, there are 6 committees under the General Assembly, and cybersecurity is directly covered by the first committee. The first committee deals with disarmament and international security.
Hello, testing, testing.
And then the third committee, that third committee deals with social, humanitarian, and cultural issues. And that committee successfully finalized the negotiation on the so-called Cybercrime Convention. So first committee, cybersecurity, and third committee, cybercrime. But the second committee dealing with economic and financial issues deals with digital trade, and digital trade is also involved in or with cybersecurity. I'll tell you briefly later. And the fourth committee dealing with special political and decolonization, and the outer space is one of its agenda. And very recently, in the meeting of corpos, on the outer space, in the legal committee, there was a suggestion that they should discuss cybersecurity in the outer space. So cybersecurity is very important in the activities of the UN. And between 2004 and 2021, there were 6 GGEs. And I fortunately attended the 4th and 5th GGEs for 4 years with my government. But the membership of the GGEs is closed and limited, between 15 and 25. So all the UN members were not allowed to join those GGEs. And so there was a kind of fighting between 2 or several blocks of the countries of the UN members. And then somehow Russia thought about another idea. So give up the GGs and create another one that is OEWG, open-ended working group. So open, that means open to all the UN members. So this idea may be democratic, but many countries, many states in the beginning were worried about, those small number of countries in the GGEs did not work very well in a sense. Then how all the UN members could do, work for agreeing to cybersecurity issues. But GGEs, they work very well, I think. How overall GGEs and OEWGs worked or achieved at least 3 results. First, they set the agenda to discuss cybersecurity. So those items are the favorite or permanent items to discuss these days. So first, starting with existing potential threats, and to discuss norms, and then international law, and then confidence building measures, and then capacity building measures, and then regular international dialogue. It is a common agenda for discussing cybersecurity. And we are, at law school, so how about the application of international law to cyberspace? And fortunately, it was agreed that international law, including the Charter of the United Nations, is applicable in cyberspace. I mean, in terms of the UN, the use of ICTs. And then GGs and OEWGs have agreed 11 voluntary non-binding norms. When I attended, as an advisor, the governments in the GGEs, they discussed the norms. So I'm an international law professor, then we need the discussion of international law, but somehow states and governments, they were discussing norms. So I found that there is a real gap of rules applicable to cyberspace. So international law, but international law, why international law cannot exactly applies to cyberspace, then there should be something for a gap. So the norms, which are voluntary and non-binding, but the states currently, they need this kind of rules, not fully obligatory, but voluntarily states are asked to do something. So they agreed 11 norms. And so this is a kind of, the answer to what's going on. How cyberspace or cybersecurity is governed. So the 6th GGE, they concluded in 2021, they describe as a cumulative and evolving framework for the responsible behavior of states in their use of ICTs. And they cover norms and international law and confidence building and capacity building measures. So they are the agenda for discussion. And cumulative. So cumulative indicates what has been agreed in the past GGs and to be agreed. They are all important and they could be recognized as a precedent in a sense, and also evolving. Cybersecurity is based on ICTs and computer networks, and technologies are developing and developing. So norms and rules should follow the development of those technologies. So rules should evolve according to the development of technologies. So this is what the 3rd GG in 2013 agreed. I read international law, and in particular, the Charter of the United Nations is applicable and is essential to maintaining peace and stability and promoting an open, secure, peaceful, and accessible ICT environment. So international law applies to cyberspace. When cyberspace was recognized, then cyberspace is based on ICTs. ICTs are invented and made by humans. So it's different from natural domains like land, sea, air, and outer space. So cyberspace was recognized as totally a new domain. So many people thought that for a new domain, there should be a new type of international law. But soon, states agreed to the applicability of existing international law to cyberspace. So we often talk about the technology neutral or neutral technology. I mean, law applies, whatever the technology is. So it is also important for, talking about the AI, artificial intelligence. So now, at least since 2013, that year, the first edition of Tallinn Manual was published. So 2013, for me, is very important for studying cybersecurity. So now the matter is how international law applies to cyberspace. So if you read Tallinn Manual, especially 2.0, you can imagine how international law applies. But the book is not recognized as authoritative by state. It is just a work of academicians or experts. But still, if you want to write a paper on cybersecurity, then Tallinn Manual provides a lot of issues or a lot of points for you to write, because the textbook Tallinn Manual raises many issues to be settled by the states. So international law covers first customary international law. For example, the right to self-defense. And especially Article 51 of the UN Charter is about self-defense. But for cybersecurity, self-defense raises many issues. Armed attack occurs, if armed attack occurs. So when in cyberspace, armed attack is recognized to happen or to occur, it is not an easy answer to that question. And it is very difficult to find who did it. So although international law, including the right to self-defense, applies to cyberspace, but what and how the right to self-defense is recognized in cyberspace is, another matter. And conceptually, some countries oppose to the right to self-defense, although it is the main and most important principle or right in international law, because if the right to self-defense is recognized, then cyberspace could become militarized. In cyberspace, there is armed conflict. But we see really in cyberspace, the militaries, they fight each other. And then 11, voluntary non-binding norms. As I said in the beginning, it is rather, uneasy concept to me or to other international law professors. But if you look at the second bullet point, norms reflect the expectations of the international community. And norms set the standards for responsible state behavior. If you studied, about the emerging
Hello. Hello.
Thank you. So these days, if you study cyber and AI, then you hear about often responsible use of AI and here responsible state behavior. So responsible is very important, but what is responsible depends on the countries. So there should be an international standard. And here for cybersecurity, 11 norms were agreed by the fourth GGE in 2015. But now the issue is how to implement those 11 norms. And I just briefly, talk about the due diligence. In most cases, for example, Korea, very recently, Korean Ministry of Defense, its websites were, victim to cyber attacks, DDoS, and our government is trying to find who did it, and the newspaper says most probably from the another country. Then, in international law, it is open. The hackers are outside of the victim country. And somewhere in a state, then in international law, that territorial state has an obligation to stop the launch or kill the cyber attack to another country. So their territory, each territory of the state is not allowed to be used for, bad things, bad purposes. But interestingly, due diligence is regarded as part of international law, especially for environmental purposes. And many international law professors regard due diligence as a kind of general international law. And many countries, many states think that way. But in the UN, GGE, and OEWG, due diligence is part of norm, voluntary, non-binding norm. It is not part of international law. So how to apply international law to cyberspace has many, many issues to be discussed and agreed. So here, due diligence, the state of due diligence is not yet settled internationally. And a new treaty. So many countries, especially China, Russia, and they're like-minded, they argued for a new treaty for cyberspace. But the US and its like-minded did not accept or has not accepted that idea of a new treaty or treaty. Why? It is kind of political thinking, but it also reflects the current state of how international law applies. That is not well settled. So they cannot be codified in a treaty. So if there is no such content to be in a treaty, then how come, why states start the negotiation over a called cyber treaty. But somehow, I think, I mean, if we look at the outer space, if we look at the sea, the air, for each domain, there are certain treaties for specific application. So I think someday we need a treaty. I mean, specific rules for how to, I mean, govern cyberspace. But at this moment, it is not yet the right time for those states to agree to a new treaty for cyberspace, cybersecurity. But later, I will very briefly talk about cybercrime treaty. It was, I mean, agreed. It's wonderful. So until a treaty is negotiated and adopted, we need customary international law by building up state practice. So many countries nowadays announce what they think of applying international law to cyberspace. The US, China, Russia, the UK, Germany, Australia, France, many countries are showing, I mean, let the world know what they think of how international law applies. So if those state thinking and announcement have some common ground, and then there will become customary international law, then it could be expected to, I mean, make the cyberspace more stable and more secure. So until the adoption of a new treaty, state practice should be very important. Now, Cybercrime Convention. Some students know that there is already a Cybercrime Convention, which is negotiated and agreed by the Council of Europe in Europe. But again, Russia and China and the others have criticized that convention called Budapest Convention or Cybercrime Convention. That is only regional because it is agreed among the European countries of the Council of Europe. But somehow, again, Russia initiated the adoption of a cybercrime treaty. And this time, it was successful. So in the UN General Assembly, an ad hoc committee for negotiating a cybercrime convention was established in 2019. And in 5 years, August this year, the committee approved the consensus draft text, the UN Convention Against Cybercrime. So now it is most likely that in addition to a regional cybercrime convention in Europe, Budapest Convention, then we will have a kind of general or universal treaty on cybercrime negotiated in the UN. But there are many opposition to the finalized text of the convention. Even many very important senators in the United States and NGOs and high-tech companies. So it is planned to be adopted in December this year, but at this moment, anyone does not definitely know, this convention could be adopted. And especially, there is a new president elected, so we should wait and see whether this convention could be adopted. Now, UN Security Council, as you know, the Security Council has the primary role for international peace and security. And for cybersecurity, China was the permanent member to raise the issue, but informally through the area formula. But the Estonia and Korea, not 2021, but 2024, this year. So now the Security Council, in addition to General Assembly, they are working at the cybersecurity. And cybersecurity for digital threat, like Professor Qureshi, my own area is international economic law, like the WTO. And these days, the FTAs, free trade agreement, they have the digital trade chapters or independent digital trade agreements agreed, and they have an article on cybersecurity. Why? Digital trade, simply speaking, trade in data. Data flows through cyberspace. So in order for trading data or digital trade to prosper, then cyberspace is to be secured. So digital trade should come together with cybersecurity. So those trade agreements involving digital trade, they must have cybersecurity provision. And very recently, in July this year, the WTO members, 82 members, including China, they agreed a plurilateral trade agreement. It is called the Agreement on Electronic Commerce. And it has also a provision on cybersecurity. So even the WTO, one of their activities is related to cyber now. And I'm approaching to the end of my presentation. Now, I'd like to share with you what the states stand about the cyber issues. So this slide shows the state stance when in 2018, when Russia and also when the US initiated a separate resolution. And this slide shows the Russian initiative for an OEWG. And the red color indicates those states opposing the Russian initiative. So you see left side, US, Canada, and in the middle, the European Union members, and Australia and Japan. And Korea abstained from that initiative. And then Also, about the same time, the US initiated another resolution for keeping the GGE process. So the last and sixth GGE was established later. And again, the US initiative was opposed by the red colors, indicating, China.
Hello, hello.
Thank you. So there is a, split between the two blocks. On the one hand, China and Russia. On the other hand, the US and the European Union members. And between, there are certain states in Latin America, in Africa, in Asia. They accepted the two initiatives. So you see this kind of geopolitics. And I think, especially cybersecurity, AI, so-called emerging technologies, they are now general purpose technologies. They are used everywhere, even for military purposes. So states are now competing very hard, very harshly. So this kind of geopolitics, I think, remain for the time being. And you, as a young student, it is you to resolve those, conflicts of geopolitics among the states, especially between the US and China. So my final observation. Cyberspace now is not an independent and new domain any longer. So you should leave cyberspace. You should leave the rules relating to cyberspace. But the problem is the rules are not yet settled internationally. And I said deepening geopolitical conflict. So there will be, in the near future, no, peaceful state over the regulating the cyberspace among countries, among states. So in the meantime, voluntary and non-binding 11 norms may work. And also in the meantime, states should develop and announce what they think of how international law applies. And finally, I think this final point, I like this point, but this is not my invention. I borrowed somewhere. We need a new application of existing international rules and norms for international peace and security as provided in the UN Charter. We also need to develop new principles contributing to emerging norms for it. So our mission and your mission is find a new application of existing international law. I said due diligence. I said right to self-defense. We have the rules, but we need a new interpretation of the rules applicable in the context of cyber. And beyond that, we may need another rules. But at the moment, which cannot be agreed, but in the meantime, we need some kind of norms which are to be observed voluntarily because it is not yet binding, not yet obligatory. But anyhow, we need to develop new norms. So it is up to us, professors, lawyers, and young law students. So I stop here. Thank you for listening.
Thank you, Professor Park.